Yes, Mr. Pimler.
Hello, my lady. And I promised before lunchtime that I would give the reference for that judgment about reasons and the duty to give more than the test or the generic formula. And the judgment, and I apologise for not having that in the skeleton, but the judgment I meant to refer to is a judgment of Mr. Justice Scott Baker, as it then was. Crown against Birmingham City Council, ex parte B, and the reference is 1999 ELR, so that's Education Law Review 305. And the reference to the Education Law Reviews perhaps betrays that this is not a judgment in the prison context. I don't pretend to
No.
But what Mr. Justice Scott Baker there said, that when there's a duty to give reasons, and I paraphrase, it's not sufficient to merely restate what the statutorily prescribed conclusion was, or to restate the generic formula, but there needs to be specific application to the facts.
Yes, well, as I heard Mr. Justice Fordham say in a lecture, the first rule of public law is it all depends.
Yes.
What was the decision about which he was saying that?
So this was a decision about school admissions and the criteria which apply to school admissions, some statutory criteria, and what happened apparently was that the decision maker simply restated the statutory criteria for admission as the reason for refusing the admission request or admission appeal, as it was, without actually applying that statutory test or threshold to the facts before the decision maker.
What was the criterion in question?
I don't have the full judgment in front of me, I'm afraid. I'll try and find what the criteria were.
Did you say it's Birmingham City Council ex parte B?
B, yes,
B,
anonymised
yeah.
to the letter B for Birmingham.
I find a reference in Fordham Judicial Review Handbook granting JR of a decision refusing parental choice of school. The standard form decision letter was no more than a ritual incantation of the statutory test and did not deal with the circumstances of the case, brackets, which required a finding as to where the child was living. Close
Yes.
bracket.
I'm grateful. I suspect that the Judicial Review Handbook might well be where I originally had taken the citation from.
Yes.
When I relied on it for another case.
Yeah.
But that's
Okay.
that's the significance there, because while completely acknowledging that the contexts are different, and this is a prison law case, not an education law case, but perhaps there is in such a way a bit of an analogy that school admissions cases are also cases which happen quite frequently. There's a lot of school admission decisions to take, and they're not taken by judges or necessarily legally trained persons. So the same points that could be maybe made for governors who make referrals, that the standard of reasons that can be expected from them is not very high, could perhaps also be made for school admission decisions. But as Mr. Justice Scott Baker said, and I make some reliance on that, it's not sufficient to simply restate what the statutory test is. So
This was a JR of a final decision.
yes. But here the decision to refer is also final, in a sense. There's no revisiting of that. So that's just the additional reference I wanted to give for whatever weight it may bear in the prison law context. If I move then to the fourth factor, which my own friend relied on under his ground one, which is the relevance of the prior police referral. And the appellant says that the existence of a prior police referral, which the referring governor had mentioned in the referral decision, was relevant, and the IEA could properly rely on this as sufficient consideration. at least part of my learned friend's argument, is that if a referral is made to the police, this implies that even the extended punishment powers of the independent adjudicator were seen as inadequate, hence the police referral, and that therefore means the matter is very serious indeed. Essentially needs no further reason. And as your Lordship, your Ladyship know, the Deputy Judge dealt with this at paragraph 28 to 29 of his judgment. And he looked, and that's core bundle 73. It's a page reference. And the Deputy Judge dealt with that argument by looking at the crime in prison referral with its referral criteria and guidance. My learned friend has taken you to that crime in prison referral agreement. I won't repeat that exercise, but what Mr. Mercer noted, and I would say correctly in my submission, the criteria for referral to police under that agreement are different from those for referral to the independent adjudicator. And his interpretation of the agreement, having spent some time on it during the hearing below, his interpretation of the agreement was, I quote, "A referral to the police for assaults on staff is to be made, save for a few exceptional cases. But if the police then decides to reject the referral, this does not predetermine the question of whether the disciplinary adjudication that follows should be undertaken by an IA or locally by a governor." And in my submission, there was nothing that was wrong about that conclusion. Because if one looks at the relevant criteria of the agreement, and it is at supplementary bundle 1-1 if anyone wants to go to it, but my own friend has taken you to it. If one looks at these criteria for police referral, there's a provision that all staff assaults are to be referred to the police. That's paragraph 1, save when there was little or no injury. That's the first provision. Then it says in paragraph 2 that if there is no or less serious injury, dealing with it by adjudication may be more efficient. But there is a caveat to that, which is if a member of staff requests that the crime is referred, the prison must do so. And then it goes to paragraph 4 about factors indicating a referral to the police. And it says each incident should be considered on a case-by-case basis. And then it gives a number of different factors there. Now, there is not really evidence as to the reasons why the first governor, who made the police referral, made this referral.
Can we just look at it again,
yes,
Mr. Bimler?
Page 171 of the core bundle.
Yes. Sorry, the core bundle.
Core bundle, yes. 171. It's the first paragraph in handwriting there, by the first governor on the 8th of June. Due to nature of this charge. So some similarity there to what the second governor afterwards said, which is also nature of the charge. So the first governor also not really spend a lot of time explaining why he's referred the charge to the police, but I make no specific complaint about that because that's not what this judicial review is about. But the only thing I say is that we do not see much in the first governor's consideration either of why this matter needed to go to the police. We certainly don't see the governor applying his mind particularly to the crime police referral agreement or saying, well, I've considered the factors, and even though this is one of those assaults with little or no injury, I've considered that because of factor X it should go to the police. So we don't have that. Now, per the Vasey judgment of the criminal division, it's perhaps not necessary to have more elaborate reasons for a police referral. I don't seek to quarrel with that, but the converse that flows from that is that this generic reasoning for the police referral, while perhaps lawful in itself for a police referral, does not assist the appellant on the validity of the independent adjudicator referral. So the appellant cannot say, well, the first governor has already considered seriousness, has already explained factors why it should go to the police, and the second governor could, in essence, incorporate that seriousness consideration, because the first governor has not gone beyond the nature of the charge either, and has not explained why this assault, which didn't cause injury, merited a police referral. Now, my learned friend has taken you to a slightly different guidance about police referral. So we've looked at the crime in prison referral agreement, but my learned friend has also taken you to paragraph 2.23 of Annex A to the adjudications PSI. And it's perhaps just worth looking at that again quickly, but having in mind the timings of these different guidance documents. Because if one looks at the PSI, the front page of the PSI, which is supplementary bundle, page 13, the front page of the PSI tells us that it was issued on the 21st of December 2018. That's in the top quarter of the page as a line issue date, 21st of December 2018, effective from 1st of February 2019. So that's when this was last updated. And if one then looks at paragraph 2.23, which is page 41, paragraph 2.23 starts by referring to the appropriate handling of crimes in prisons protocol, and then gives a web link to that. And that is not the same document. So the appropriate handling of crimes in prisons protocol is not the same document as the crime in prison referral agreement. It's the predecessor document. Because the crime in prison referral agreement only came into force in May 2019. And you have that from its cover page, which is supplementary bundle, page 112. So the crime in prison referral agreement was from May 2019, some 5 months after the PSI was issued. So of course it's not mentioned there yet. PSI couldn't anticipate what the May 2019 policy document would say. But in my submission, at the time of this case, the authoritative guidance on police referrals was in the crime in prisons referral agreement. So paragraph 2.23, which summarizes the appropriate handling of crimes in prisons protocol, and it doesn't really give its own guidance because it says this is what the appropriate handling of crimes in prison protocol says. It gives a web link, but it briefly summarizes it. 2.23 is outdated actually, because the PSI was at that time, at the time of the case before this court, it hadn't been updated to incorporate the new crime in prison referral agreement. So in my submission, 2.23 doesn't help the appellant here because it's outdated guidance. But even if one were to think the appellant could rely on 2.23, even if one were to think, well, 2.23 had some freestanding force, even though it refers to an older protocol which is no longer now applicable. In my submission, 2.23 does also not assist the appellant in the way he submits. Because if one goes back to the wording of 2.23, and again it's page 41 of the supplementary bundle.
Just a minute, I hadn't spotted this point about the protocol being out of date.
I've mentioned it in my skeleton argument.
I'm sure you did. It's my fault, not yours. But are we reading too much into 223 refers to the superseded protocol,
Yes.
sets out the principles relating to the referral, etc. in situations where a serious criminal offence appears to have committed. Police should be contacted immediately. Yes. This protocol, presumably the same one, sets out which crimes must be referred to the police. And then other crimes are referred to the police where it is determined that the relevant internal disciplinary processes are insufficient to deal with the offence and where circumstances indicate, etc. Is that quoting from the protocol, or is it a statement which is substantively part of the PSI?
Well, I say, but we don't have the protocol in the bundle, so I don't want to say too many things about the protocol without giving evidence. But I say this entire paragraph summarizes the old superseded protocol. It essentially gives a précis of the protocol for those who don't want to read it in its entirety. But even if that were not so, even if one were to say 2.23 standalone guidance and goes perhaps further than the protocol, I say that properly interpreted it still doesn't help the appellant, because if one reads 2.23 that way, then it says that there are three circumstances in which crimes are referred to the police. Firstly, there are crimes which per the old protocol must be referred to the police. That's that first sentence. This protocol sets out which crimes must be to the police, referred to the police. And then it says other crimes. So if one is not in that mandatory category, then it says there are other crimes which are to be referred because it has been determined that the relevant internal disciplinary processes are insufficient to deal with the offence and circumstances indicate that referral to the police is appropriate. That's category 2 for a police referral. And then the third category is at the end of that sentence, or where the victim requests police referral. So the third category is crimes which don't meet category 1 or 2, but the victim said, I would like this to be referred to the police. And that's important in my submission when one looks again at the justification which the governor gave for referring to the police, because the governor said, due to the nature of the charge, it is to be referred to the police. So in my submission, that implies the first governor considered these to be one of these automatic or mandatory referrals, a category 1 referral, crimes which must be referred to the police. Because there is no evidence that the governor who referred to the police has thought about whether the relevant internal disciplinary processes are insufficient to deal with the offence. He simply said due to the nature, so category 1 referral, not category 2 referral. So I don't accept, with respect to my learned friend's submission, that because the first governor referred to the police, ergo the first governor must have thought the relevant internal disciplinary processes are insufficient, and therefore that's a good foundation to say it meets the independent adjudicator's threshold.
Look, surely referral to the police is a more serious disposal than independent adjudication.
Sorry, I didn't catch
It's a more serious approach or response to a situation than independent adjudication.
It can be, yes. But it has a different, it may
I'm
be...
saying it's different, but I mean, on the face of it, for a governor to send something to the police indicates that the governor takes a graver view of it than if the governor simply referred it to adjudication.
Well, I'm not sure it does, because it says here, in because the protocol has been set up in a way that it says certain crimes must be referred to the police. So in certain instances, there is actually not an individual consideration for the governor to think, is this so serious? But there are certain crimes which must be mandatorily referred. So I wouldn't say that one can read the PSI or the guidance in a way that says only matters which are even more serious than an independent adjudicator referral will be referred to the very different referral processes which have their own criteria. Because the converse, if that were true, if one said that, well, referral to the police is always an indication that something is more serious than if it were to be referred to the independent adjudicator, then afterwards there would not need to be any determination anymore, because then clearly one would have a presumption that if something has been sent to the police, if it comes back, it must go to the independent adjudicator. But the appellant's policy is very clear that this is not how it is, and I take that from 2.28, which is overleaf, page 42. Because there, 2.28 deals with what happens when things are come back from police. So it says, and accept that, it says the most serious disciplinary offences will normally be referred to the police and prosecuted in the courts rather than adjudicated. But then it says, but if the case is not referred, or no prosecution follows and the adjudication resumes, the adjudicator should then consider whether to refer the case to an IA. And then it says, if the prisoner is eligible for additional days, that's just whether he is determined or indeterminate, and the adjudicator considers that the offence is serious enough to merit this punishment if the prisoner is found guilty, then the case should be referred. And I say that's quite significant, because the policy could have also said, well, serious things are referred to the police. If the police sends it back to you, you or your fellow governor has already decided that it's serious because you've sent it to the police, therefore you can send it to the independent adjudicator. But that's not what the policy says. The policy says expressly, if the police return something to you, you then proceed to make your seriousness assessment, and you then proceed to decide on the basis of Rule 53A, which is different from the criteria for police referral, whether you refer to the independent adjudicator. And
haven't we rather skipped, sorry to interrupt, Mr. Chairman, haven't we rather skipped over 227, which I hadn't noticed before? I mean, it's not automatic to refer to the adjudicator when the case comes back from the police, because it depends what they've said. If they said the CPS advise us that there's no reasonable prospect of conviction because the evidence appears not reliable or credible, the governor to whom the case comes back has got to give pretty serious thought to that as to whether to go ahead at all.
Yes. And indeed, if one reads the last sentence of 2.27, which is just before the next subtitle, each case, so when a case comes back from the police, each case should therefore be determined on a case-by-case basis, considering why a criminal investigation isn't being pursued. Any reasons why a case was not prosecuted should be noted on the record of hearing, and if a case is referred to an IA, it must be recorded on the referral form, IA1, under additional comments. And of course, there's no comments here. And I don't try to make a new point on an appeal, which I haven't taken before, but it's another, I think, part of the argument that there needs to be reasoned consideration by the governor, because 227 tells him if a case comes back from the police, but the governor still wants to go forward with the adjudication and indeed wants to refer it, it must be mentioned on the referral form why the case was not being prosecuted by the police after it was referred to the police. And there is certainly no evidence that the governor did that here. So in my submission, there is no support in paragraph 228 and onwards, or indeed in paragraph 227, for a proposal that the mere fact that a matter had been referred to the police can bear any weight or relevance to the Rule 53A determination. Because what is important is, firstly, why was it referred to the police on the which of the factors, especially in a case like this, which was a little or no injury case, which shouldn't be automatically referred. And we have no information about why it was referred other than the nature of the case. case, and secondly, because the governor should think about why the police sent it back and did not prosecute it. And neither was done here. So that's why I say, when the independent adjudicator simply saw that the governor had written because of the police returning the charge, that could not satisfy her that the governor had actually put his mind to the right test. So, in my submission, none of the four factors advanced by my learned friend are really capable of disturbing the reasoning of the judge below, the fundamental reasoning, which was that the independent adjudicator had not shown reasons, lawful reasons, why she could be satisfied that the governor who referred the matter to her had actually properly addressed the test for referral. And the simple reference to nature of the charge, or nature of the offence, and the fact that it's been to the police and back, was not sufficient for her to find that she has enough evidence that the governor has properly undertaken his role. These are my submissions on ground of appeal 1. Unless your lordship, your ladyship has any question on that, I would move on to the second ground.
Yes.
I'm grateful. I accept, of course, that the appellant has raised the Section 31 argument in his skeleton argument in the High Court. It was done rather in passing, and the reference, if it helps your lordship, the reference is paragraph 11 of the appellant's trial skeleton, and that's core bundle, page 95. So at page 95, paragraph 11, in the court below, end of paragraph 11, the appellant said, if, which is not accepted, there was a procedural error, then the court is invited to have regard to section 31 2A of the Senior Courts Act. And from my note, my learned friend also made brief reference to that in his oral submissions at first instance. What is still interesting to note is that the section 31 2A argument was not relied upon by the appellant either in the summary grounds of defence or in the detailed grounds of defence. Now, I don't intend to take a pleading point on that. I don't say that the appellant is somehow shut out from raising it because he didn't plead it in the defence. Just to provide some context as to why Mr. Mercer case he might have omitted to address that particular submission in his judgment. I think it's certainly fair to say that no detailed submissions on section 31 were made either in writing or orally in the proceedings below. But I do accept, and I'm bound to accept, that the deputy judge should have dealt with the section 31 point once it was raised in the skeleton argument. And I'm bound to accept that he's not dealt with it in the judgment. And so that's why a respondent's notice has been lodged, seeking to uphold Mr. Mercer's relief order on additional grounds.
Yes.
And of course, it only arises if your lordship and your ladyship dismiss the appeal on ground 1, otherwise it falls away. But if the appeal is dismissed on ground 1, then in my submission, this court is in as good a position as anyone to deal with the 31 issue for itself, rather than remitting the case to a fresh High Court hearing simply on section 31. The reason I say that is because the section 31 issue, as indeed the entire case, only concerns written materials, which are before this court as they were before the court below, and as they would be if this was remitted for a section 31 determination by a different or same or a different judge of the High Court. There's no advantage which the High Court would have. Can I therefore, on that basis, make a few points about section 31 and what its relevance is in this case? And for your reference, my lady, my lords, we have section 31 at page 1 onwards of the authorities bundle, which is page 4 in the electronic authorities bundle. The general points which I would make about section 31 are the following. Firstly, that the burden of proof for a section 31 2A submission lies on the defendant who raises it. and that simply follows from the general maxim that he who asserts must prove. But I also cited an authority for that in my skeleton argument, which is the Bokrasova case, Mrs. Justice Elizabeth Lane in 2015. That was endorsed by a number of further first instance decisions, which I've not cited, but I hope it's not a controversial point. And secondly, Section 31.2a refers to if the conduct complained of had not occurred. So it's quite important, certainly for this case, in my submission, to ascertain with some precision what the conduct complained of actually is. And
Well, you've set it out very succinctly in your respondent's notice.
Yes.
I think Mr. Grandison came close to conceding that if he wins on ground one, then ground two it falls away, as you say. If he loses on ground one, it's because we have accepted your argument that the independent adjudicator had no jurisdiction to proceed because she could not be satisfied that the referring governor had addressed, is it his or her mind? His mind properly to what he had to do. If it's right that the independent adjudicator should have declined jurisdiction, then, as I see it, the Secretary of State can't be rescued by Section 31.2a.
Yes. My Lord, I entirely agree with this. There is perhaps a danger of having been succinct in the respondent's notice now trying to go.
You put it very well. But if we get this far, then yes, Mr. Grandison's in trouble, and I don't think we need to hear separate argument on ground two.
I'm grateful. In that case, I don't propose to trouble the court with it. In any case, my slightly more elaborate argument on it is in the skeleton argument, if it assists. And
yes,
I was not going to really make more points than that.
Right.
Unless I insist.
Thank you very much, Mr. Bimler. We're very grateful to you. Mr. Grandison.
Thank you, my Lord. Can I respond just very briefly, please? Firstly, with one matter of clarification. I think it was in relation to factor 2. My learned friend indicated I was criticising the nature of the submission focusing on mitigation of sentence. I wasn't. The focus of that submission was in relation to the points made by the Deputy Judge at paragraph 30. So the factors such as COVID conditions, the nature of the letter, relationship, so on and so forth. Those are the factors that I was referring to when referring to mitigating the sentence. It was nothing to do with submissions made by Mr. Conningham at the application dismissed before the governor. So just in case it wasn't clear, factor 2, reference to mitigation, are those points addressed by the Deputy Judge at paragraph 30. If I can briefly address three of my own friends' points, I'll do this incredibly succinctly, taking them in reverse order. The relevance of the reference to the police. My own friend refers to 3 possible routes, so either mandatory referral, inadequacy of the disciplinary regime, or victim. Now we can discount the third, we know it wasn't a victim referral. That's not referred to in any of the documents whatsoever. If one can look at, very briefly, the relevance of the mandatory offences, you'll note the nature of the offences are the most serious on the criminal calendar. I'm not talking about the disciplinary calendar here. You've got rape, you've got murder, you've got terrorist offences. Undoubtedly, that crosses the seriousness threshold. And so the only real criteria at stake is that the governor considered that the independent adjudicator's powers were inadequate. And that we submitted in terms of order of severity. Referral to the police is the ultimate, then referral to the independent adjudicator, and then, last but not least, the governor dealing with it in-house. And so the reference to the police is relevant for that reason, because they have the power to obviously prosecute the matter through the CPS, opening up a whole new avenue of possible sentences for the offender. The second point I wanted to deal with is my learned friend refers to the nature of the charge, and of course that was terminology used by the governor a great deal, but I don't think when they're referring to the nature of the charge, it's simply referring to assault. I think one has to view it slightly more broadly than that, because of course the reference is made with the charge sheet in front of them. This is when the governor's making the first decision to refer it to the police. The second governor's referring to the independent adjudicator, and the independent adjudicator is considering whether or not to dismiss it. The nature of the charge is that document. So it's not just simply an assault, it is an assault in that context.
Page one, this page 163.
That's correct. So it's core bundle 163.
Yes, it says you committed the following offence. Commits any assault on prison officer.
Yes,
Details of alleged offence, which you took us to.
that's correct.
But somehow it morphs into 4 charges.
Yes, I think that's because this paragraph here is then used for the other remaining 3 charges, so it's duplicated
Yes.
across each of the documents.
Where are they set out?
So I can give you the page references. So as I said, it's a great deal of duplication, but
If I can assist, it's 195.
that's correct.
It's the second charge.
225 is the third, and 250 is the fourth.
Oh, I see, right.
And it is, I'm afraid, cut and paste. There's nothing new contained within it, save for the
195 and then
195, 225, and 250.
yes, thank you.
Thank you.
Just before we leave this one, these forms are a 10-page form,
Yes.
and we've looked at the charge at the beginning of it, towards the beginning, and then going to the well-trodden page 171. We see that the Section 6 record of hearing, it's not, as it were, a very big hearing at that point, because it's simply putting the charges,
Yes.
where we see evidence read out. So one takes from that the bit at the top as to what is said to have happened is read to the prisoner, who answers various questions
That would be my
in the
understanding.
format. And so what is written below in the first instance appears to be written at the time that the charges are put,
That's correct, yes.
with the information in everybody's mind. The second one is obviously at a later
That's correct.
a later date.
Yes. My learned friend, obviously, I know I have the right to reply, but I'm not looking to him to correct me if I'm wrong, but my understanding is that a charge will then be read out at the hearing. So that box, which of course is, so box details of alleged offence at 163 is then considered by the governor at the first hearing and put to the prisoner. Of course, the prisoner has that record from the outset, so the time period within which the charge must be served stops when that document is given to him and served upon him. So the references to nature of the charge, I don't accept simply to an assault. It's wider than that. And then finally, in submissions from me, I'm grateful for the court's intervention on these points, because my learned friend's position has remained resolute that no matter how serious, or obviously serious, the offence is, no matter how obvious it is that the test has been met, my learned friend's position is that reasons must be given by the governor when referring the matter to an independent adjudicator. That there's no scope for any reference to nature of the charge, police referral, things like that, that one cannot look at the context. And that, we submit, is wholly wrong. In a system that prizes expediency, informality, and, upon proving guilt, swift justice, these challenges that place technicality above substance cannot be allowed to stand. My Lord, unless there can be of any further assistance.
Thank you. Thank you, Mr. Grandison. Thank you both very much. We'll reserve judgment and consider what you've said. We will send out a draft in the usual way. I'm sure counsel are familiar with the rules, but I am required to restate them in every case. Firstly, the draft is sent out not for re-argument, but for correction of typos and obvious factual errors. It's also sent out under the obligations of confidentiality contained in the judgment of the Master of the Rolls in the Counsel General for Wales's case. We hope it will be possible for an order to be agreed when you have our draft judgment. We're very grateful to you for your assistance. Thank you.